Case number 21, CR 36, State of Ohio versus Madeline G. Burnett. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant is Attorney Jake Wagner. Are you Madeline Grace Burnett? With the defendant charged with malicious assault and corporate investigation. Matter set today for a status hearing, and I think that trial date set in September. That was continued, and I'm not sure what the trial date is, but I have been provided with a guilty form, Miss Arnett, which indicates you're going to withdraw your not guilty guilty. This form is 4 pages in length, and the prosecutor's office prepared it from a form that they have. On page 3, down towards the bottom of the page, there's a sentence that says, "I enter this plea voluntarily." And immediately below that, there appears to be a signature of Madeline Arnett. That's your signature I'm looking at here?
Yes, sir.
And when did you sign this document?
Just now.
Did you go over this with your attorney before you signed it?
Yes, please.
When you signed it, did you understand it's an agreement to plead guilty, which means there's not going to be a trial? The next step in your case would be a sentencing hearing.
Yes.
And is this something you've been just talking with your attorney about before today?
Yes.
So when you came here today, did you think this was something that might happen?
Yes.
You had enough time. Have you had enough time to fully consider this matter for making this decision?
Yes.
Are you entering into the agreement to plead guilty voluntarily?
Yes.
Right now, it states on page 1 that you're going to withdraw your not guilty plea, plead guilty to both counts of the indictment. Count 1 being malicious assault under section 2903.11A2, a secondary felony. Count 2 being a forfeiture specification under 2921.14.17, revised code. The penalty for first count as a second-degree felony states that the maximum prison term is to be imposed by the judge is 8 years, minimum could be 2. There's a fine available of up to $15,000, and it is presumed that a sentence of prison should be imposed for this offense. Now, under the law, this particular charge is under what we call rape toast law, and that means that persons that are convicted of this offense, the judge sentences them to any term between 2 and 8 years in prison. And then the Department of Corrections determines if the person should be released at the end of that term, or they should be required to serve an additional period of up to 1/2 of whatever prison term is imposed. So, if the maximum prison term of 8 years is imposed, that means that there could be potential, actually, of 12 years in prison. If the minimum of 2 is imposed, there could be 3 years, because that's each of those are half of the number. Do you understand that?
Yes.
And again, that's up to the Department of Corrections. The judge has nothing to say about that. Now, under the law, once you, if you're sentenced to prison, and you serve a prison term, once you complete that prison term, it is mandatory that you be put under post-release control supervision by the adult parole board. And that would be for at least 18 months. It could be up to 3 years. So you'll be supervised in the terms that the parole board says, because of course not qualified. And if they determine that you have failed to comply, then they would have the right to return you to prison, even though you served the entire term set by the court plus any additional time Department of Corrections required. For an additional period of up to 9 months for one violation, but there is a cap or limit. A cap or whatever the prison term was for all violations that they may find. However, should you be convicted of a felony, then in addition to whatever sentence the judge in the case imposed upon you, that judge could also sentence you to an additional period for committing that offense under post-release control in this case, to a period of 1 year, whatever time is left upon the post-release control, whichever was greater. And if that occurred, that would have to be served consecutively the sentence in the new case. You understand that?
Yes.
Right now, under the law, this is not a mandatory prison offense, so I don't have to sentence you to prison, although there's a presumption that I should. And so what that means is if I decided not to sentence you to prison, you would put under the supervision of the probation department under terms set by the court for a period of up to 5 years. Now, if during that period of time that you're being supervised, the probation department felt that you were not compliant, they would file a red notice at the court, sort of copy on you. And if the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for a period of 8 years, minimum up to 12-year maximum, and fine you the maximum fine of $15,000. You understand that?
Yes.
Now, the charge in count 1 alleges that on or about January 21, 2021 in this county, you did knowingly cause or attempt to cause physical harm to John Henry by means of a deadly weapon or dangerous ordinance to wit a Cal-Tec 9mm. Deadly weapon is defined under ORC 29.3.11a, which would be a violation of 29.3.11a2. So that's the felonious assault. Carries a possible minimum term by the judge of between 2 and 8 years and a maximum term of up to half of what the prison term was imposed, determined by the Department of Corrections, and a fine of $50,000. Count 2 alleges that on or about January 21, 2021 in this county, you had in your possession a Cal-Tec 9mm holster and clip subject to forfeiture due to its instrumentality and commission facilitation of the offense, as defined in section 29.1.14.17. So, saying that's the gun since that was allegedly used in count 1, that if that is defining that it's subject to forfeiture, meaning that you lose any right to ownership of that, and it would go to the law enforcement involved in the prosecuting case. Do you understand that?
Yes.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, possible outcomes of the trial with your attorney?
Yes.
And are you satisfied with his advice and confidence in his matter?
Yes.
Are you under the influence of any types of drugs or alcohol?
No.
Have any threats been made against you to plead guilty here today?
No.
Now, on page 3, there are several lines printed boldly and underlined. So I'll read that as this time. It says, defendant shall either plead guilty to the indictment. State defense jointly recommended 4 years incarceration. Second is 11 months in case number 20 CR 216. The defendant agrees to the forfeiture specification outlined in count 2, the indictment, and the state will not oppose judicial release to residential treatment after 18 months incarceration. And is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
We haven't imposed, there hasn't been a sentence imposed on 20 CR 216 yet.
No, she's currently treated.
Pardon me?
That's a treatment in the case.
Okay, well, we don't have that case up here. So, then we have to pull that.
Yep.
20.
Your Honor, if I may,
CR
I don't know if the court would be inclined, we want to ask for a sentencing date.
Yeah, that's fine.
I just didn't know if you needed it for now, or
Right.
the sentencing.
20 CR 216. Now, under the law, by the way, the state's consulted with the victim of this, and, for this, allegation, alleged
Yes, Your Honor.
under the law, Mr. Arnett, the matter of sentencing is not, up to the parties, it's the judge's decision. And so, even though there's a recommendation you should get 4 years, plus 11 months on the other offense, once I decide, once I've heard all the information presented to me, if I decide that's not the correct sentence, I could impose a sentence of anywhere between 2 and 8 years in this case. And what is the charge in the evidence?
It's an F4, taking
F4. So that could be up to 18 months, because your conviction in this case would constitute a violation of your intervention term, would result in that case, your guilty plea being entered, as already entered, it would be accepted, and there will be a finding of guilt because of that violation. You understand that?
Yes.
Again, that sentence would be in that case up to 18 months. You understand that?
Yes.
All right. Now, there's also a statement that the state's not going to oppose judicial release treatment after 18 months. Again, the matter of judicial release is up to the judge, not the parties. So even though the state's not opposed, that doesn't mean it'll be granted. I'll certainly consider it. I always consider it, almost always consider it if the state's in opposition. Not always, sometimes I'll decide no. That's not going to happen, I won't even consider it. But I would consider it most likely, unless there's something comes up, you know, that leads me to conclude that it should even take the time to have a hearing. And so I could decide to grant you that, or I could decide even after the hearing that it's not appropriate. Do you understand that?
Yes.
Now, do you hold any license or certification from any state governmental agency regulating any trade or occupation?
No.
You have certain constitutional rights that you must understand before it can accept your plea in this matter. First of all, you have a right to have an attorney, and I'm sorry, yes. And Mr. Wagner's been appointed to represent you in this case, and I believe you were attorney in the other case as well.
No, I took this case over from Ms. Hatter. So Ms. Hatter had this case prior to the other case.
Right. And so his appointment wasn't simply work the case out, but to provide any defense that could be available to you under the law that you wish to provide. So if you decide that you don't want to do this, then we will still represent you and defend you in this case, including a trial, if that's what you want. You understand that?
Yes.
Right, now, under the Constitution, you have a right to have a jury trial in this case, in which 12 people will be selected from a group of citizens that reside in this county that are summoned for jury duty on your trial. After they are selected, the evidence will be presented, they'd be instructed on the law, and then they would have to decide by unanimous verdict, between all 12 have to agree, whether the state proved your guilt by proof beyond reasonable doubt. Now, you didn't want to have a jury trial, but you didn't want to plead guilty, then you can waive in writing, which means to give up, the right to have a jury trial in this matter, and then in that case, you would have what's called a court bench trial. That means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to confront a witness against you, cross-examine through your attorney. What that means is that the witness against you have to come into court and testify in front of you and your attorney and anyone else can be present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Right, now, under the Constitution, you have a right to use the power of this court to help or force witnesses to come to court to testify for you, the same as the state. So, if you have witnesses you're not certain whether to voluntarily, you request court issue a court order is called subpoena, now force those witnesses to come to court to testify on your behalf, even though they didn't want to be involved, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes.
Right, now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify, not used against you in any way by any person at any time, no one's even going to comment about it except in one situation, which is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider that for any purpose. You understand that?
Yes.
Right now, under the Constitution, you are presumed innocent of this offense until proven guilty by the state of Ohio on every essential element of the offense. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this offense. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Understand that?
Yes.
Now, originally, you pled not guilty to these charges in Ms. Arnett. That plea denied the allegation and the indictment denied you committed any crime and invoked or exercised all the rights that I described. Change your plea from not guilty to guilty. That is the opposite of not guilty. The guilty plea admits the allegation in the indictment in both counts, admits that there are crimes, and that plea gives up all the rights that I've explained to you this morning, except your right to have an attorney, which you always have no matter what you plead. With that exception, you plead guilty with waive or give up your right to a jury or court trial, waive or give up the right to confront witnesses against you and cross-examine through your attorney. Waive or give up the right to use the power of the court to compel or force witnesses to come into court and testify for you, the same as the state. Waive or give up your privilege of self-incrimination because if you say you're guilty, that's what you find you guilty. But waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And it also waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other limited circumstances, you can file an appeal. That would have to be filed within 30 days for sentencing it to be filed. You understand all that?
Yes.
Now, also, as I explained, a plea of guilty would also, resulting conviction, result in your intervention in lieu of conviction charge in 20 CR 216, which I believe is attempted tampering with evidence, fourth-degree felony, that one of the conditions in your treatment is you comply with all laws, all jurisdictions. And so by pleading guilty in this case here, you would be, end up committing a violation of your rules and that would result in that intervention being terminated, you being found guilty, and subject to being sentenced to a period of between 6 and 18 months, fine of $5,000 in addition to the 8 years and $50,000 in this case. And again, those sentences would be served consecutively. You understand that?
Yes.
All right. And are you a U.S. citizen?
Yes.
Do you have any questions about the charge in this case or the possible penalty?
No.
And again, you understand it would also result in the penalty I just described in a attempted tampering charge in your other case.
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have any questions about pleading guilty, what it means, or what the consequences of that will be if you enter in this case as well as in the other case? You understand?
Yes.
Anything you need to speak with Mr. Wagner about before we go any further?
No.
Have any questions about anything that I've discussed with you this morning? And is it your decision to withdraw your not guilty plea, plead guilty to both counts of the indictment and forge the terms of the plea agreement we just gone over?
Yes.
Right, then as to count one, which alleges that on or about January 21, 2021 in Tyne County, Ohio, you did knowingly cause or attempt to cause physical harm to John Embry by means of a deadly weapon or dangerous ordinance to whether Kel-Tac 9mm. A deadly weapon is defined in ORC section 29.3.11a of the Higher Revised Code to charge of felonious assault with a second-degree felony, bearing a possible minimum term of between 2 and 8 years set by the judge with a maximum being of up to 1.5 or 50%, whatever sentence is imposed by the judge in addition as determined by the adult parole or the Department of Corrections, and a fine of $15,000, and also would result in a revocation of your termination of your intervention, finding of guilt and sentence in 20 CR 216, the attempted tampering in evidence charge. How do you plead?
Guilty.
As to count two, which alleges that on or about January 21, 2021 in Tyne County, Ohio, you had in your possession a Kel-Tac 9mm holster or clip subjects to forfeiture due to its instrumentality in commission or facilitation of the offense defined in section 2941.14.17. And forfeiture specification would result in the loss of that weapon and all rights to that weapon to the state. How do you plead?
Guilty.
Thank you. You see. All right, court finds on this day, open court, penalty by law and constitutional rights may one help with voluntary way of same percent to 11. Please accept the order filed and found guilty of this. Now, when you give me a sentencing, or me a hearing notice sheet, this other case. Case number 20, CR 216. The defendant entered a plea of guilty to attempted tampering with evidence, a fourth-degree felony. The defendant was acquitted to an intervention due to conviction due of a finding of guilt, and instead of back on January just entered a plea guilty in the 20-36 case. I'll need to have another affidavit or financial disclosure form filled out with, Arnett, but, I'll go ahead and appoint Mr. Wagner to represent you in that case. Now, because of this conviction, in the case that would be a violation of this, you would be entitled to have a hearing in the matter to, have it presented on that, Mr. Wagner, do you wish to have a hearing on this matter, or are you, waiting to hearing and agreeing that she has violated this conviction?
I would wait to hear Madam understanding, kind of looking at this conviction, it violates your conviction, you understand that? Or we can go ahead and stipulate that it is a violation.
All right, so you've been violation of, condition.
Yes, sir.
Okay. My understanding is the request that the sentencing be deferred on this for a couple of weeks.
Yes, sir, if we may, Your Honor.
All right. Well, I don't need a new report. I have a report before January, so I think needs to be done on that. So, let's see, today is 27. I'll probably remember the 10th when I have this order check and all the rest of this. And we'll set for sentencing in both cases on the same day. November 1st, pardon me, 10th. Yeah, that's all I have to say. All right. 9 a.m. Wednesday the 10th.
Yeah, that'll work, Your Honor. Next, have a DR court, this will take precedence.
Yeah. All right. 9 a.m. Okay. So, we'll be back here 9 o'clock. There's a recommendation to send to prison if that occurs, which is highly probable, given the nature of the offense. You'd be going to custody that day. All right, anything further?
There you go.
No, sir.
Thank you.
Thank you.
Case number 21 CR 86, State of Ohio versus Dustin L. Swords. President of the state is Assistant Prosecutor Kane, President of the defendant, Attorney Jacob Wagner. And is not present. Do have an affidavit from Mr. Argino indicating that he has not contacted the probation department since August 27th when he called in and said he had to quarantine due to COVID. And then also, according to FRS, he refused to submit drug testing on September 21 and 24, submitted on the 4th, was positive for amphetamines, and he is not present here today. Mr. Wagner, have you had any contact from him recently?
I have not, Your Honor, I was just checking my phone to confirm that. I called both numbers I had had yesterday, that being 205-38-93 and 272-0536. I called both of those numbers at 2:28, 2:27 yesterday. It rang, went to a voicemail, said those mailboxes were full. My last contact, I saw my client on High Street. I was driving down one day, he was going to book right in front of Taco Bell. It was the last time I saw him. I did not pull the stop with him. I had my kids. That's the last time I've seen him.
Okay, well, court orders a case issue for investigation, put on an action docket. We'll, try to get these taken into custody.
Yes, sir.